Well, good evening, everyone. Thank you so much for joining us tonight. My name is Carly Shortino-Polter, and I'd like to welcome you to Ask the Arc. I'm actually really excited about tonight's presentation because we have a wonderful guest that's joining us tonight. I'd like to introduce you all to Justin Shrock, who is an attorney at Indiana Disability Rights. He's been with them for 10 years, but he's been working with individuals with intellectual and developmental disabilities since 2007. I've known Justin for a long time, and I'm very excited he's joining us. Justin heads up the Indiana Disability Rights Self-Determination Team, where they do a lot of work trying to help people stay out of unnecessary guardianships, but then also looking at allegations of abuse, neglect, or financial exploitations within the guardianship realm. And so Indiana Disability Rights really has been at the forefront of guardianship and especially alternatives to guardian, including supported decision making from the time it was first conceived here in Indiana. And so I'm very excited for Justin to join us tonight. In addition, I do want to remind everybody that we are recording tonight's session. So as you're asking questions, I do want to make sure that you're a little careful in what you say, just because this will be put on our YouTube channel for others to be able to watch. And when it comes to asking questions, I ask that you put those in the Q&A, and we'll be able to answer your questions as we go along. But at this time, I'd like to say welcome, Justin. Thank you so much for talking to us tonight.
Thank you very much, Carly, for that very warm introduction and for allowing me to speak to you and the audience tonight. And I also appreciate everyone taking the time to join tonight. And I hope that this is an informative and at least mostly interesting presentation.
All right. Again, so if you've got any questions, go ahead and put those in the Q&A. We'll stop at different points to be able to ask questions, just so that we are making sure that we're answering everything, because I know that there's a lot of confusion when it comes to guardianship, and a lot of people aren't necessarily 100% sure what all they need to do as a guardian. They've heard different things, and so this is a great way to be able to learn about what your responsibilities are, what your obligations are under guardianship, also what limits there are to guardianship, and really also how to potentially work off of guardianship if that's part of the goal. So at this point, I will turn it over to Justin and let you take over.
Thank you, Carly. I will go ahead and share my screen and hope we can avoid issues with the tech.
We're seeing your screen, but not your presentation. There we go.
Okay. Are you seeing the title screen now?
I am seeing both. I'm seeing your title screen and the next screen.
All right. Well, that is frustrating. Let's try that again. Screen sharing. You were seeing the presenter view just now.
I was.
Okay.
Don't know if that's because I was a co-host, though.
Mm. All right, start this again.
I'm still seeing presenter screen. If somebody in the audience could put in the Q&A whether you guys are just seeing one slide, they're seeing presenter screen too.
Okay.
There we go.
All right. We're good now? Okay. So you're just seeing the title slide. Okay.
Sorry. Yes.
Yeah, we ran through this before the presentation, everyone, and we're not having issues, but this is why this always still makes me anxious. So yes, welcome everyone, and tonight I will be presenting on guardianship responsibilities and specifically focusing on the responsibility to promote independence and self-reliance of the protected person under guardianship. And it's important to note that Indiana uh, presently is one of only about a handful of states that does not have a statutory right to appointed legal counsel in adult guardianship proceedings. However, we are still out there as far as attorneys who do exclusively or primarily represent individuals who are subject to the guardianship system, whether that be prior to establishment of guardianship or while guardianship is already in place. And so some disclaimers that I want to cover before we get into the presentation is that, as I alluded to, in my practice, I exclusively represent individuals who are subject to Indiana's guardianship system. I do not represent legal guardians. So the usual disclaimer that is part of presentations like this, that this is not legal advice, that applies doubly here. As However, as an attorney who frequently deals with problematic guardianships, after all, people aren't usually contacting me when things are going really well. Uh, my intention tonight is to be able to provide some very generalized information about guardian responsibilities and best practices to help those in the audience avoid future issues within guardianships that they might be a part of. Um, and the reality is that Indiana courts, unfortunately, do not have the staffing and resources necessary to hold guardians' hands and ensure that the law is always followed every step of the way. But that doesn't mean that if things go wrong, that the guardian will end up being held responsible, because at the end of the day, you know, if there are issues that need to be addressed, as the attorney for the protected person, I'm generally going to be pointing the finger at the guardian, not the judge. So something that important. And as far as what we'll cover tonight, like I noted, we'll be talking very generally about guardianship, what it is, what it is not. It is important to note that in the United States, guardianship is exclusively a matter of state law. Um, that doesn't mean that federal constitutional protections and things of that nature don't apply. However, how things work in Indiana is not the same as how they work in Ohio or Michigan or Texas or California. There are a lot of similarities, and there's a lot of crossover from state to state, but ultimately state law is what governs how guardianship works in an individual state. Like I noted, we'll be talking about the general responsibilities of legal guardians. And then rather than having this be exclusively 45 to 50-minute PowerPoint presentation, my hope is that around the 25-minute mark, we're going to end the PowerPoint, and Carly and I are instead going to have a discussion or a Q&A of sorts, talking about best practices for legal guardians to follow in order to help support the independence and self-reliance of protected persons. And then we will also be holding some time at the end for questions from the audience. And before we get into the real substance of the presentation, I want to share this graphic to help everyone visualize the spectrum of available options to help support a disabled adult in managing their affairs. And they go from, at the top, the least restrictive options, to the most restrictive there at the bottom. And as you can see, on one end, we have informal or otherwise minimal supports, and at the very opposite end, we have guardianship. And that's because while even I am not someone who will say guardianship is never appropriate, it absolutely is for some individuals. It is the most restrictive arrangement that is available under United States civil law. There's literally no option more restrictive than guardianship, which is why, although we won't be likely to be covering alternatives to guardianship in great depth during this presentation, I do just want to make sure and highlight that guardianship really should always be an option of last resort. And I also want to note that, and it's something we might hit a little bit during the presentation, something to keep in mind is, guardianship can always be an option if some of these less restrictive alternatives that are out there prove themselves to be insufficient or otherwise inappropriate. So I'm assuming those in the audience are generally familiar with what guardianship is. However, just to kind of make sure we're all on the same page, I want to note, it is a legal proceeding whereby someone or sometimes multiple people are appointed by a court to manage the care of someone who's adjudicated to be legally incapacitated. And that can apply to either their person, which includes things like their daily care, matters relating to healthcare, housing, education, work, etc. Or it can separately or also apply to the protected person's estate, which includes finances, paying bills, protecting assets and property. And we'll be covering it in a little bit of depth later, but I do just want to highlight that fiduciary duties do apply to guardians of the estate. And it's important to note that for legal purposes, a guardian effectively steps into the shoes of the protected person. From my experience, I know there's a lot of misunderstanding about the nature of guardianship authority, and I've encountered some legal guardians who believe that they can essentially force third parties to bend to their will, and really any matter relating to the protected person, they have sole and final say over it. And that is simply not the case. Really, anything that the protected person themselves would be unable to do if they possessed those legal rights themselves, a guardian is probably not going to be able to validly do. It's also important to note that the authority of the legal guardian flows exclusively from the appointing court. So it doesn't matter if that's one particular judge overseeing the case. Sometimes it's a number of judges or magistrates, which are kind of junior judges, so to speak. And really, while most courts are not in the business of trying to micromanage what a guardian does or doesn't do, you do need to keep in mind that all actions and decisions made by a guardian are subject to review and approval. I guess you could say disapproval. Also important to note that the best interest standard is what guides how guardians are supposed to carry out their duties. And that's not necessarily what the guardian always feels is best. And that really needs to be analyzed through the lens of how would the judge in the case view this particular situation. And that's why it's really important to keep an open mind as legal guardian and to listen to what the protected person wants and what's important to them, and to also consider suggestions and other input from uh, other individuals in their life, whether that be family, friends, or professionals who are working with them. So then to briefly cover what guardianship is not, um, I noted before that guardianship is not the default or only option for assisting a disabled adult in managing their affairs. And in fact, there is a wide range of potential options available when someone happens to have a disability and may not be able to manage their affairs entirely on their own. In the vast majority of my cases, no one is ever trying to assert that the individual can, simply go off on their own and they would be able to independently, uh, manage their finances and benefits and medical care without any help. All of us need help from time to time, some of us more than others. But simply needing assistance with those things does not mean that you need your rights removed by a court and give it to someone else. Um, Guardianship is also not a one-time court proceeding. As we'll talk about, there are continuing duties both to the protected person and the court that the guardian has that even go beyond the life of the protected person at times, and even go beyond if the guardianship itself is terminated while the protected person is still living. Um, and I also want to emphasize again that guardianship is about managing affairs, not controlling them. That is unfortunately another very common thing we see is, I guess common is not necessarily the right term, a not infrequent occurrence that we see are guardians who, you know, want to dictate what the protected person has for every meal, what they wear on a daily basis, how their bedroom is decorated, who they talk to, when they talk to them. And frankly, that is, while I can't say some of those things might never ever be appropriate in any circumstance, uh, in general terms, those would be examples of abuses of guardian authority and not within the legitimate realm of uh, what the law actually provides for. And so moving into the responsibilities of legal guardians, and I noted at the top some of the statutory code citations where these are summarized. And I will note that Indiana's guardianship code is unfortunately not a great source of guidance for legal guardians or anyone else. It is in significant need of updating. And there are thankfully various efforts underway to do that. That is a very slow process though. But the Indiana Guardianship Code is extremely vague in most respects. It's silent on many important issues. Um, there are a lot of provisions where it's difficult to tell if uh, the particular provisions are applying to guardianships over children or adults or both. There's a lot of contradictory provisions and contradictory language, which just makes it difficult for everyone, including guardians, to do their jobs appropriately. So with that noted, I did still want to provide an overview, both what is explicitly or not so explicitly stated within the code, with a little bit of some best practices mixed in as far as what the responsibilities of guardians are under Indiana law. And the first one should be fairly obvious, and it's that the guardian genuinely needs to know what's going on in the protected person's life. And so that requires maintaining regular contact with the protected person, as well as other individuals and professionals involved in their care. And that doesn't mean that the guardian has to do everything. And in fact, you know, in most circumstances, that's not what we want. We want the protected person to be able to have the ability to make decisions about as many things as they reasonably can, and to have opportunities to build skills and get experience with various activities of managing their affairs. And guardians can also rely on things like waiver team members and other professionals who might be involved in the protected person's care. However, at the end of the day, the guardian is responsible for making sure that those things are those activities and duties are carried out. And I do also just want to note that as part of this responsibility, the protected person's values, goals, and preferences should always be given primary consideration before thinking about any for protection that might be necessary. And that's not to say that, you know, what the protected person wants should always be what's determinative. Case, there probably wouldn't be a guardianship in place, right? However, that should be the first consideration rather than thinking theoretical risks as far as what might happen. That sometimes does need to come into play, but those any rights restrictions and things of that nature should be narrowly tailored to actual tangible risks that are based on perhaps things that have actually happened, or that there's a clear nexus as far as the need for that. And other basic responsibilities include ensuring that the protected person's basic needs are met, as well as ensuring that the protected person receives appropriate medical and other professional care. And these responsibilities are highly intertwined and often require making sure that the protected person is receiving and maintains eligibility for whatever state and federal benefits are potentially available to them that they're eligible for. So that can require, or that can include Social Security benefits, SNAP, housing assistance, Medicaid, Medicare, whatever applies to their situation. Because while legal guardians generally are not responsible for paying out of pocket for these sorts of things, the guardian is responsible for making sure the protected person does not go without and that their needs are not met. So I think getting into potential liability is probably a little too, I guess, theoretical to kind of talk about as far as part of this presentation. But that is always a possibility if the guardian is neglecting to ensure that these basic needs are provided for. And this slide would apply to guardians of the estate, which would be wrapped up within most Indiana guardianships. I believe the last statistic I saw was something like 89% of guardianships in Indiana are plenary or both the person and estate. But managing, conserving, and protecting the finances and property of the protected person are very critical if the guardianship does extend to the protected person's estate. And I will note that while something like being a representative payee for someone technically does not fall under the purview of the guardianship court, because the Social Security Administration is responsible for overseeing that. That can fall within the guardianship estate because that is property that oftentimes the guardian themselves is responsible for managing. And in whether we're talking about being a payee or being a guardian over someone's estate, it's important to note that the fiduciary duty does apply. Sorry, our Google just responded to me for some reason, if anyone could hear that. Fiduciary duty does apply to legal guardians. And without getting into too much detail about what fiduciary duties are, the central aspect is that the fiduciary must act exclusively in the best interest of the person who they're acting on behalf of, here being the protected person under the guardianship. And that includes, prohibitions on things like conflicts of interest. It includes a prohibition on commingling or mixing guardianship funds with those belonging to the guardian or other individuals. That is an issue that I've seen come up in several cases that I've handled. And oftentimes it's not something that the guardian necessarily knows is wrong on the front end, or at least that's what they claim. However, what's important to know is that that is something to be avoided at all costs, because once the guardianship property is commingled or mixed with your own property or that of someone else, it becomes next to impossible to be able to track how those funds are spent over the long term. So don't do it. That's the best advice I can give you there. And as a best practice tip, maximal transparency regarding the management of finances is generally going to be the best route. That's specifically as applied to things like statements and other financial records. I know that for many protected accounts, things like payee accounts and guardian accounts and such, the protected person or beneficiary is barred from having direct access to those funds in many circumstances. That now, it doesn't mean they can't be provided some of those funds. They just can't typically have direct access to the main account itself. However, there's generally never any legitimate reason why the protected person or beneficiary shouldn't know what's going on with their money. And being highly transparent and being judicious about sharing bank statements and other financial records, not only does it help prevent suspicion brewing that there might be wrongdoing going on, it can also help avoid potential issues. I've been a part of several cases where a guardian or payee was very closely guarded about records, whether that involved refusing to share any information at all, or only being willing to share limited information about how finances were managed. And then we later found out that the payee or guardian wasn't necessarily stealing money, but they weren't appropriately managing it. I think the most common example is, we finally get a hold of the records, whether through subpoena or through some other means, and find out that the individual has been over-resourced for several months or years, which then can jeopardize their Medicaid coverage, their SNAP benefits, their housing assistance, all of those important benefits that they need just for their basic needs to be met can be jeopardized if those funds aren't managed appropriately. And as a lead into the next responsibility, I do want to note that guardians are statutorily required to keep and maintain appropriate records of their management of not only finances and other property, but of their general activities as well. And the next major responsibility of legal guardians is reporting to the court on the status of the protected person and or estate at least every other year. Some courts will require reports or accountings to be filed annually, or depending on the circumstances, sometimes even more often than that. And this is another area where there is a lot of confusion, and that's partly because in many counties, this is not a requirement that has been strictly enforced historically. However, I have noted that more and more courts are making a push to require both guardian reports and guardian accountings. And while a lot of the reports and accountings that I see are very minimal and provide next to no substantive information, a best practice tip would be to take the reporting requirement very seriously and make efforts to meaningfully and thoroughly inform the court about what's been going on in the protected person's life, what you as guardian are doing to manage their affairs, both related to their person and related to their estate. I've never heard of a judge get upset about being overly informed about what's going on with a protected person, but I can tell you I've encountered a lot of judges who got upset about not being informed about significant events that have gone on in the protected person's life. I do also want to highlight as part of the biennial or every other year reports that are required since 2019. There has been a requirement to make a specific showing of whether the guardianship is still necessary and appropriate, along with whether less restrictive alternatives to guardianship have been considered or implemented. And along with that change in 2019, there has been a requirement added on the front end of guardianships for the filing of petitions themselves that has a similar showing that is required. And while I can't say that's always enforced, that is legally required under Indiana law, and something that is important to make sure that you as the guardian are genuinely making an effort to do, even if the court may not affirmatively require that all the time. And related to reporting requirements, there are several types of occurrences or instances that either require guardians to seek and obtain court approval prior to acting, or else where seeking and obtaining the court's approval is strongly recommended, even if statute doesn't explicitly say that. So that includes the protected person here. I shortened that to PP. moving out of county or out of state. Um, a lot of judges aren't going to get too upset about being informed after the fact about someone moving out of county. Particularly in the waiver context, that's not all that uncommon. You should still be making sure to inform the judge of that as soon as you can if you are seeking approval for that prior to the move. And I do want to note the statute does say that is required to get the court's approval prior to a move out of county. Um, moving someone out of state, that absolutely that should never be done without first getting the court's approval. And that can get you in some significant hot water if you tell the court after the fact that you've relocated someone out of state, because again, guardianship is exclusively a matter of state law. And so once you've moved someone out of state, not only can that cause issues with the guardianship, but that's something that can also jeopardize various state benefits that we've talked about previously, like Medicaid and housing assistance and such. It's also depending on what the specific purchases are, it is generally required, or at least strongly recommended, to seek the court's approval prior to making any major or non-routine purchases or investments on behalf of the protected person. And that does include if you as the guardian have retained an attorney who you're paying with guardianship funds. Per statute, you should be getting the court's approval before doing that. Now, most judges are not going to deny a request to pay those attorney's fees, but those are required to be reasonable. They're required to be necessary for carrying out the guardian duties, and they're also required to be of benefit to the protected person. So if you are not taking that step to get the court's approval prior to paying those legal fees out of guardianship funds, you risk being personally liable for those after the fact. Selling any property, particularly real estate, vehicles, things of that nature, should always seek the court's approval prior to doing that. Generally, prior to engaging in any estate or long-term planning on behalf of the protected person. That includes establishing things like a special needs trust. Again, that's not something judges are typically going to decline doing, particularly when it's necessary, but that is the requirement to get the court's approval for that is intended both so the court is aware of what's happening with those funds, and also to make sure that that's being done correctly, because a lot of these things are very legally complex, and if you try to do them yourself and mess it up, you can end up being held responsible for that. And lastly, a change of placement or other significant modification of services and supports. That is generally something that even if the code doesn't explicitly require that, that is very strongly recommended that you seek the court's approval for that, particularly if the protected person perhaps needs a more restrictive placement than where they've been historically. And lastly, I would recommend considering outside of the required biennial reports, notifying the court of major occurrences in the protected person's life. So that could include things like extended hospitalizations, changes in long-term living arrangements, or long-term employment, long-term relationships. These are things that, the code doesn't explicitly say you have to report this to the court. But again, These are things that can be very significant in the protected person's life and really impact what level of outside supports they need, what level of informal supports. So that is information that can be a very good idea to report to the court, just so that the judge is aware. And then the last responsibility that I wanted to cover, and this is something that Carly and I will be discussing here in more depth here in a few minutes, is the requirement to encourage self-reliance and independence of the protected person. And there's, again, among the various misunderstandings out there, although it's called permanent guardianship, guardianship is not necessarily always intended to be permanent. And really, even if it's realistically very unlikely to happen over the long run, the ultimate goal of guardianship, and really, if the guardian is really kind of doing everything to the best of their ability, it should be to prepare the protected person for the eventual restoration of rights. And by that I mean it, and that would include, of course, terminating the guardianship either partially or totally. That again does not mean the then formally protected person would be walking off into the sunset on their own without any help. And virtually every guardianship termination I've been a part of, and I think I've done a bit over 30 of them at this point. I don't recall a single one where we weren't establishing some other decision-making supports as part of the termination effort. Because, as we know, a lot of times there are continued support needs that are going to extend into the future, but ultimately that doesn't necessarily mean that guardianship is necessary. So, all right, I am going to stop my screen share, and then I will hand it over to Carly.
Well,
On.
Justin, first of all, I want to thank you so much for all of that. I know that there wind up being a lot of questions that people have, and in fact, by the way, we've got about 14 questions in our Q&A already. But a lot of times people have questions and they don't necessarily have anybody to ask those questions to. I also want to say, because we touched on a lot of different topics tonight, I do want to make sure you know that on the Arc of Indiana's YouTube channel or on the Arc Academy, you can also get a lot of other complimentary webinars on things like guardianship and alternatives. How do you do supported decision making and a lot of other things like that. So we've got some supports that way as well that you can watch whenever you actually have time to do that. Um, but I want to thank you for going through all of that and especially for bringing up some additional topics today. One of those topics that I really wanted to make sure we talked about was this idea of restoring somebody's capacity. Really, and what that means is, guardians are supposed to help individuals continue to learn skills and continue to develop so that they can eventually work off guardianship or work off as much of guardianship as possible so that they can regain their ability to make decisions. And this is not an all or nothing thing. And like Justin said, even though it's called permanent guardianship, it's not a one and done sort of a thing. Part of it is as family members, as loved ones, as people who work with individuals with disabilities, part of what we're supposed to do is help them grow as much as possible, to help them learn how to advocate for themselves. And a big part of that is through supported decision making, either through the formal process of having like a legal supported decision making agreement, which you can do in conjunction with guardianship, or in a more informal way, especially, in the beginning. And you should be starting that as early as possible. Yes, I literally mean using supported decision making with a 4-year-old. Not even joking. It sounds ridiculous, but part of that is helping our loved ones learn that their opinion matters, that their voice matters. But then it's also about teaching them who are the people I can go to when I have questions. Who can I get reliable information from? I saw it on Facebook, not a reliable source. That's just my personal bias here. Um, but really helping them identify who are those trusted people that we can go to, making sure that we're introducing them to the pharmacist at the drugstore so that they can develop that relationship so that your loved one knows that pharmacist and the pharmacist knows your loved one, at least in passing, so that when your loved one has a question, hey, you know what? I got this weird rash. Is there something I can use for this? Pharmacist already knows, oh, sure, Annie, let's go over to aisle 3, and that's where we're going to see this, or whatever the case may be, because it's in developing those relationships, even when they seem superficial, where it's just, hey, we say hi to each other a lot. Um, that's what develops those relationships so that when our loved ones do need some help about something, whether it's the pharmacist, whether it's the banker, whatever the case may be, there's familiarity there. And as a result, there's that comfort in being able to ask those questions. So that's one thing I want to say. And especially when it comes to like banking, because I know one of the biggest concerns or the two big areas that people have concerns with are going to be the financial piece and then the medical piece. Well, how many people actually go into a bank anymore? Almost nobody does. Everybody does things online. Everybody does things through an ATM. But if you actually go into the bank every so often and you introduce yourselves to the bank tellers, you make that familiarity connection, then if something ever gets screwed up with somebody's bank account, you can go in and you can, because you've developed that relationship, even if it's just saying hi, every week or every other week or whatever the case may be, when they need help, it's, hey, I know you. You're somebody I recognize. You betcha I'm going to help you. And we're going to stay a little longer because you're somebody I know. So that makes a huge difference. Um, you know, maybe that's, setting up like something called a True Link card where you're putting money, it's a refillable, I don't know, I can't call it a debit card, but kind of like a refillable, um, it's not a credit card either, but you know what I'm trying to say, a refillable gift card, essentially.
Well, they're basically the equivalent to green light accounts for
Hmm.
kids, right?
Hmm.
It's a way where typically a guardian or payee can give what's essentially a debit card
Hmm.
to the beneficiary or protected person. You can transfer money onto it, either on a regular basis or maybe when needs arise, and they give the guardian or payee, whatever role you're acting in, not only the ability to track expenses and where purchases are made. You can also individualize certain types of businesses that purchases can be made at. You can set limits for how much can be spent in a day or how much can be spent in a week. And while that could be seen as, well, what's the point? In some cases, particularly if you have let's say your guardian for your adult son who's 21 or 22, he lives with you, you guys have a good relationship, you make sure his bills are paid and give him cash when he needs it. Why, why do we need something like a TrueLink card? And really the benefit there, among some other ones, is that um, that's really it's a means for the individual to be able to get some experience in a kind of protected environment, to have that freedom to go out and grocery shop on their own, or stop at the gas station and get a snack and a drink, without necessarily having to, run it by mom. Hey, can I have another $10? Can I have $20 to go to a movie with a friend? Um, and to get that experience in a circumstance where the guardian or payee or what have you still has the ability to uh, intervene if there's some indication of someone exploiting the individual, or even if they just have a poor understanding of money and tend to blow through whatever they have available to them. No one can learn how to do those things and build those skills unless they have those opportunities to practice and mess up and learn and get better. I mean, that's just how it
And
works
there's
for
also,
anything.
there's also a lot of satisfaction and a lot of pride in knowing that you can stop at the gas station and get a soda and a bag of chips, or that you can go down to Jimmy John's and get a sandwich for lunch. There's I see that in my son is, there's this little bit of pride that, yeah, I can do that. And in part it's because he works and so that's, part of why he's having that and all of that. Um, but there are a lot of intangible benefits to this as well. And yes, and especially, you mentioned, somebody who tends to go through money a little bit quickly, by doing that, if you say, put $50 on that card each week, yes, they're going to have to face the consequences of what happens when that card is out of money. And so that way, we're making it a little bit more concrete, but in a safe way. I will also say that when it comes to supported decision making, one of the other benefits to using supported decision making is that, ideally you sit down together and you talk things through. You talk through the issue and the question, and you come up with the questions you need to deal with. So first of all, it's a way to continue to make or to teach decision making skills. And it's also a way that you can help impart your values as they are learning those decision making skills. Now, let's be honest, just because you impart those values doesn't mean they have to embrace them. We all may have disagreements with our own parents on certain things, but it's the way that we can help shape this and the way we can help teach them how to make decisions. We can teach them, okay, what are the questions I need to consider? Who are the people I can go to? And then, like, literally learning how to make a pros and cons list to help them make those decisions, or however you make your own decisions, and teaching them those skills. And I think, and maybe this is my own bias, but I think that as parents, in particular, because our kids went through school and had IEPs, we are so used to this concept that we have to achieve goals in a year, because with an IEP, our goals are written for one school year. Um, that's totally out the window in real life. Nothing has to be done within a year. Well, with a few exceptions, you do have to make your reports to the court. You have to file your taxes. You got to do your Medicaid financial redetermination. So there are some things we have to do literally on an annual basis. But this idea of learning a skill, it can take 6 months, it can take 5 years. Who cares? Or we can continue to be working on those things and recognize the progress that they're making, even if they're not independent yet. And Justin was absolutely right. We talk about independence and we talk and especially when we talk about working off a guardianship or terminating a guardianship, you know, nobody's ever alone. It's not like we're pinning a 20 to their chest and wishing them the best of luck and saying, see you later. We're still in their lives. And ideally, we want to help them build a circle of support so that, when they have those questions, they have those people that they can call and they can talk to. But again, people aren't alone as they do all of this either. So, um, Justin, is there anything you want to add before we start looking at questions?
Yeah, kind of on the topic of building a circle of support, and just kind of the general idea of building skills and independence and why that's important. Um, I know one understandable reason for hesitation that a lot of particularly parental guardians might have to kind of uh, opening up the I'm not sure what the best terminology I'm thinking here. Kind of loosening the reins a little bit and letting your loved one be able to build those relationships and have others be able to assist them and help them build skills as well. Is the concern that they might be taken advantage of or abused in some way, especially if there's been some history of that in the past. But what's important to keep in mind is that the more empowered that an individual is, whether they have a disability or not, the more likely that they're going to be able to recognize when they're being taken advantage of or they're in an unhealthy relationship. And the more avenues for assistance they're going to have if they find themselves in a bad situation in the future. I know the worst circumstances I see is when someone has uh, sheltered to too far a degree, and maybe something happens to the parent, whether they're guardian or not, and then the individual that they haven't had to develop
Mhm.
those skills, and so if they fall into those situations, they don't know how to recognize when those problematic things are coming up or who to go to help them get out of them.
Yeah.
And so that's just something to kind of keep in mind.
And it's counterintuitive because as parents, and I'm one of them, as parents, all we want to do is protect our kids. And so many of us, basically, if we could wrap our kids in bubble wrap at all times, we would do that because that would make us feel safe and we'd know that they are safe. But this is why it's counterintuitive, because when we're doing that, what we don't realize is we're actually isolating them. And so that actually puts them at greater risk when we are teaching them to be more independent, when we're teaching them, to make their own decisions, when we are valuing their decision and accepting their decision. And don't get me wrong, man, sometimes that is so hard to accept their decision, especially when we don't agree with it. But in doing that, we show them that they should expect everybody to respect their decisions. They should expect everybody to respect their opinions, especially when it comes to their own lives. And that is actually how we make them safer, is by teaching them those skills and by teaching them that they have the right and they have the expectation that they should be treated with dignity and respect, including in making their own decisions. And so, like, literally, like if you are at the doctor's office and the doctor looks over at you and says, "Does Jimmy's stomach hurt?" Make a big show of looking up. Well, I don't know. Jimmy, does your stomach hurt? Because there's no reason the doctor should be asking you that. They should be asking your loved one that question. And, it's more about reinforcing that our loved ones are worthy of respect and they should be treated with dignity and respect and equality, even as we are teaching them the skills they need to be able to make decisions to the greatest extent possible. There are always going to be times where they may need help with things. That's okay. We may have individuals who may need additional support. That's okay, because the reality is we all use that in our own lives all the time. How often do you pick up the phone and call, your best friend or your sister, or potentially even you still call your parents to ask them advice on everything from, "Oh my gosh, my water heater is leaking. What do I do?" to, you're talking to your best friend about, what's going on with the school system, to maybe talking to your parents about, "Hey, I've got this, I'm trying to figure out, should I look for a new house? Should I, go back to school?" Whatever the case may be. We all have support networks where we talk things through. And talking those things through, it helps us to make our decision. That's all supported decision making is at the end of the day. It's being able to go to people you know, to people you trust, to help gather information and talk things through so that you can make your decision. And that's something that we should absolutely be doing with our loved ones with disabilities to the greatest extent possible. Um, so we've got a whole bunch of questions that I am going to get into if that's okay. Um, how does co-guardianship work with divorced parents of a disabled young adult?
So that's a fact-sensitive question. However, something that I will note that I see happen from time to time is you'll have particularly parents divorce while a child is a minor, and then they become an adult. Um, Even though there's no legal authority anywhere for it under Indiana law, the court that oversees the marriage dissolution case continues treating it, and oftentimes they'll roll the guardianship into the divorce case. They'll keep treating it as though it's the now adult is still a child, and the court will still apply those sorts of standards that they would, if this now 21, 22, 23-year old adult were still, a 6, 7, 8-year old child, including things like uh, entitlement to parenting time and things of that nature. And while I can't, I don't know the details about your arrangement with your ex and your child and how all that works out. I think the most critical thing that I can emphasize is that the best interests of the now adult, who is the protected person, is always what should guide what decisions are made and how things are carried out. So, um, whether that's where they live, how their money's spent, I sometimes it makes sense for a young adult to split time between their parents' houses if that's what they want. But I've seen that continue far beyond what the client actually wants. They're like, no, I don't want to go. I still love my dad, but I don't want to go have to stay at his house every other week, or I don't want to have to visit him every other weekend and every Wednesday. I want that to be my choice. Um, it needs to be, again, people, once the guardianship is established, even if it arguably may or may not truly be necessary, it is in place. Um, but the best interests of the individual and what their values and preferences and desires are should be what the focus is. And that's not always going to be workable in every relationship where parents have separated. Um, and so there are some cases where perhaps a guardianship has started out as a co-guardianship and then kind of proves itself along the lines where maybe that's not the right arrangement. And even if guardianship is genuinely necessary, maybe it really should just be one parent or the other. Um, so I hope that's a helpful answer. Um, I know it's a complicated situation, and some people can make that work extremely well, and then others, I know that that would be endlessly complicated.
So this concept of co-guardians brings up a couple of other questions. Um, first of all, that idea of a successor guardian, naming somebody who you want to be the guardian, if when you pass away, or if you are unable to continue on as guardian. But also, that idea of, as a guardian gets older, should they add on a co-guardian, so that when they pass away, or if they become incapacitated themselves, that there's already somebody in place. Can you talk a little about that?
I'm sorry, Carly. I was actually reading through the question list, um, trying to sort through some of the where uh, people were kind of,
Okay.
yeah, sorry. Can you ask
Okay.
that again?
Sure. So what I was saying was, this kind of brings up the topic of the idea of a successor guardian, naming somebody that you want to take over if you are unable to be guardian, whether it's because you've passed away, or because you've become incapacitated in some way, or is it something where, especially as you're getting older, that you should bring on a co-guardian, so that if you pass away, or if you become incapacitated, that there's already somebody already there. What are your thoughts on that?
Um, so I think my initial response, and I am a lawyer after all, to every question is going to be, it's going to depend a little bit on the situation.
You guys
Um,
think I'm bad about this? I'm not a lawyer.
yeah, as far as particularly kind of planning for the future and what if something happens to me as the guardian, then yeah, co-guardianship could be a good option if it's someone who both uh, the protected person who you're responsible for caring for has a good relationship, and you also have a good working relationship with. Um, and you know, it doesn't necessarily have to be limited to circumstances where you know you're getting older and maybe you're starting to reach capacity. That can be set up and potentially beneficial even before that. And it can be arranged where one person is responsible for helping manage medical care and for attending quarterly team meetings for the Medicaid waiver services. Then the other person oversees the finances and manages those. Um, I think just from my outside perspective, I think that separation of responsibilities, at least um, maybe not to where one guardian is exclusively doing one or the other, but if there's maybe a primary and a secondary for different areas, or maybe across the board, similarly to how if you appoint an agent under a power of attorney, or you appoint a healthcare representative, you can appoint a primary agent or representative who can act on your behalf. And then if they're unavailable or unwilling to act, then it falls back to the secondary. That's something that can be used under guardianship as well. Now, as far as the circumstance for thinking about, what if something happens to me as the guardian, then having a co-guardian already named can be a good option there, because then if you yourself pass away or become incapacitated, then that co-guardian is authorized to act, and they can potentially look at getting another co-guardian named down the line if appropriate, or they could potentially take over as sole guardian long term. And that's something that needs to be considered before you have someone named as co-guardian. Is would they be willing and able to carry that on by themselves if something happens to me? Um, Another option, if you don't want a co-guardian, or if that's not an appropriate arrangement, is appointing what's called a standby guardian. And don't quote me on the statutory requirements here because this is something I deal with on a regular basis. So it's possible I might misstate something a little bit. But the idea of a standby guardian, and I'll note that I believe per statute, um, there only has to be a document that's completed and executed and notarized. It doesn't necessarily have to be filed with the court. However, I would strongly recommend if you're going to look into appointing a standby guardian that you do file that with the court so the court is on notice. And then if anything happens to you, no one's trying to have to figure that out after the fact if you get in a car accident or dropped out of a heart attack or something. But
And,
the idea of a standby guardian is that that individual is automatically authorized to step in as guardian for a limited period of time. I it's somewhere again, I don't deal with this on any regular basis. I believe it's somewhere between 30 and 90 days that the designated standby guardian is automatically, and then they're required to petition the court if they want to become permanent guardian. Um, so the benefit there is you've already got someone who can step in on kind of an emergency basis, make sure, bills are still paid, consents for healthcare and things of that nature can still be provided. But if maybe you're not quite so certain that this person is going to be appropriate to be the long-term guardian, or maybe you have questions about the long-term necessity of the guardianship, or that's someone who maybe wouldn't work well as a co-guardian, appointing a standby guardian can be a good option too, to make sure there is someone who's uh, able to step in if something happens.
and one of the big reasons that I bring this up is I have a friend who is guardian of her son, and her husband had passed away like 10 years beforehand, so she had everything set up in place for when she passed away. But she had a major stroke, and so she didn't pass away, which means all the plans she had couldn't be enacted on their own. And so, and so she has since recovered, thank goodness. And one of the things we stressed was, hey, you need to get this done instead. So that because when she was in the hospital recovering from her stroke, somebody can make sure that her son's rent was paid and somebody can make sure her mortgage was paid. I mean, because I think a lot of times we think about what happens when we pass away. There are a lot of things that can happen beyond just that. And so, talking that over with a probate or an elder law attorney, just as part of your own estate planning, is a smart and important thing to do. So we've got some more questions. And by the way, I want to thank all of you from the beginning of the presentation who are letting us know when, what you guys were seeing on your screen. Thank you for that. Thanks for having our backs on there. Are there different types of guardianship?
Yeah, I covered that a bit toward the beginning, as far as guardian of the person, which typically covers really anything impacting the like literal physical uh, body of the protected person. So things like healthcare, where they live, um, to some where they go to school, those sorts of decisions. And then there's uh, guardians of the estate, which is sometimes called a conservatorship, which would apply only to the finances and property. There is the option, and frankly, they're not used often enough, but you can use time limited guardianships. So you can ask the court to maybe only approve a guardianship for a year or 2 years, and then to perhaps have, and it's not going to be appropriate for every situation, but depending on the circumstance, it might be particularly if you have someone who maybe doesn't really want to be under guardianship, but really arguably needs it. That could be a way to kind of even hold yourself accountable as guardian, um, to where, you know, you have that time limited aspect that's kind of set on the front end. And then if it appears that the guardianship is still going to be necessary beyond that, then you can either re-petition the court, or I've even seen guardianships where, rather than it ending after a specific period of time, it was set to uh, be reviewed by the court after a year, 18 months, whatever. Many states actually require that per statute. Indiana, unfortunately, does not at this time. And then there are what are framed as strictly temporary or emergency guardianships under Indiana law. And those are primarily intended for like true emergencies. Say someone's in a car accident, they're in a coma, they don't have any long-term or estate plans set up. And so they need someone to step in and act on their behalf. Those are typically limited for periods of 90 days that can be re-upped once for a total of 180 days. And then potentially that can be converted into a permanent or long-term guardianship if need be. But there are a lot of situations where, I mean, your friend with a stroke,
Mhm.
maybe if she didn't have good long-term planning set up, maybe a temporary guardianship might have been appropriate for a short period of time, and then she recovered sufficiently after a few months, and that wasn't necessary. Um, there are I don't want to get too into the weeds here, but there are also options for dealing with things like, uh, settling a lawsuit, or taking an inheritance from a relative and placing it into a protected account like a special needs trust, making decisions about discharge from a nursing or a residential facility. A lot of things that I think people get misinformed and believe that guardianship is the only option to carry out these sorts of activities. But in actuality, a lot of these kind of point in time matters can be handled through the local probate court, or like 6 counties statewide that have dedicated probate courts. But under the probate laws in Indiana, where the court can uh, order or make decisions about certain things under what are called protective orders. That is unfortunately an example of kind of some of the confusing terminology at Indiana's guardianship code, because people are like, what protective orders? You're talking about like when someone's being abused by their spouse? No, this is a different type of protective order. Um, but yeah, I think I
Because you all know the language and the words we use are designed to be as confusing as humanly possible. So,
uh,
um, Justin, earlier you kept referencing affairs, and somebody's asking, what do you mean by that? And I think it was, like having your affairs in order and things like that. What exactly did you mean?
so affairs is a very generalized concept, and we use affairs just because that's what the the laws refer to. But really, I guess you could understand that to be activities or decisions. Um, yeah, I'm not sure if there's a good succinct way uh,
Okay.
to explain that, other than they're kind of just the activities to necessary to manage our life over the long term.
And one of the things I want to kind of point out is that, you know, The people on this call are typically involved with individuals with intellectual and developmental disabilities. And our guardianship laws really are not written with our folks in mind. They are really written to protect the family farm when grandma develops dementia. So a lot of the guardianship laws really are focused on finances and things like that. And when you're talking about an 18-year-old with Down syndrome who doesn't have any sort of, money, some of the guardianship laws and some of the requirements may seem a little strange when you're looking at it through that lens. And so in knowing that the guardianship laws really aren't written with our folks in mind, and knowing that it's, basically to like protect the family farm, it suddenly makes things make a little bit more sense, and a little bit easier to adjust to. And this leads into kind of our next question, which is, how will I know when I'm required to report to the court? Do I just do this every 2 years after initial guardianship date? Are there specific reporting requirements that must be met or templates to follow?
So, per statute, the initial report slash accounting is supposed to be filed within 30 days of the 2-year anniversary of the establishment of the guardianship. So that's the general rule. Um, and then every 2 years thereafter, that's supposed to continue. Um, it depends on the county, but I noted that many are getting better about sending out reminders to guardians about when those are due. Um, I've never seen a court where guardian just happens to miss the deadline that, the judge is ordering them in for a show cause hearing and threatening them with contempt or anything like that. That's not how it works anywhere. If you miss the deadline, and Grant, you shouldn't just be waiting for the court to remind you. That should be something that you are tracking yourself and trying to affirmatively take care of. But um, I don't want anyone to get unnecessarily stressed out, who's, trying to do their best. Um, but yeah, like noted, the general rules 30 days after the 2-year anniversary. Um, and then was part of that question about the
Is there,
information that should be included.
yeah, I think that's a good thing. And also, is there some sort of template or something along those lines?
So my advice there would be to contact the court and ask if they have any template documents for uh, their preferred information to be included in a report or accounting. I'll note
Because
that,
because part of that is every single county does things differently.
yeah,
There is not uniform, it is not consistent across the state. So every county is going to be different.
yeah, yeah. And I'll note a lot of the template forms, frankly, in my opinion, are pretty awful. They don't support being able to uh, really apprise the court of what's genuinely going on in the protected person's life. But if you've got that template form, I don't know that there's a county in the state that says you have to use this template. They generally use that as kind of a source of guidance. So you can work off that and kind of use what is relevant to the protected person's circumstances. I guess I could be wrong about that. There might be counties that do have specific forms that they require in everyone. So that would be a question to ask the court staff. But
And
that
and
is something that they should be able to provide some guidance on.
and who would they call? Like, you know,
So that's
if
unfortunately another one of those things that depends on the county.
okay.
Sometimes it's the clerk's office. Sometimes it's the court itself. Um, I think my first step would be to call just the office for the court that the guardianship is established out of. You're not going to reach the judge. You're going to reach their staff. And so you could just ask them if they've got any forms as far as what's required for those reports and accountings. Um, if they don't, then if that is something that the clerk's office handles, and they should be able to tell you that. Um, they're probably going to tell you that they can't provide legal advice, but here are some uh, forms that we provide that basic minimal information that we want. So that would be what I would recommend. And that would be for, simpler cases. If you are a guardian for someone who does have significant property and funds that are part of the estate, then I would, uh, in virtually every circumstance, recommend seeking the guidance from an attorney who specializes in this area. Um, I know that might be cost prohibitive, in which case, if you simply can't afford it, then never hurts to call the court and ask what they want included in those.
So our next question, my child, the protected person, who's an adult, has moved to a group home in another county. I've given up the financial portion of guardianship over to them. They still let me know and participate in his life, day services, behavior plan, etc. Do I need to court report this change?
So I didn't catch the name on that. So I'm a little curious as far as giving up the financial portion, if that's truly, is that letting them become
Okay.
payee
I think
or?
that's really what they've done. And what that means is, no, you are still guardian over the estate. It's just that you've allowed the group home to become the rep payee for Social Security. But you should still be doing oversight over it because sometimes I would politely say that some providers accidentally have some problems managing money, and get somebody over resourced and things like that. Um, so you can still be oversight. It doesn't mean that you're the one who's doing the day-to-day part, but you're still the guardian over that portion. And so you should still be doing oversight just to, check in every so often, make sure things are going the way they're supposed to be, make sure that your child's money is being spent on them. Um, sorry if you, I know I jumped in and answered that, but
Yeah, no, that's a great
so,
response. But yeah, there's nothing wrong if a provider offers to be payee. I generally don't like when providers insist on being payee, although there are some where
mhm.
that's called for. Um, but yeah, you as guardian, that's fine to kind of delegate that responsibility out. But yeah, you still are responsible for overseeing that. Um, and what I see in a lot of cases where that's the arrangement, is that typically the guardian is obtaining the statements from the payee, whether those be monthly or whether they're more detailed, kind of resembling traditional bank statements. And then they'll provide those as part of the accounting. And um, generally, they'll have maybe a page kind of summarizing uh, approximately this amount was spent on housing and utilities, and approximately this much on uh,
Food.
clothing and yeah, food. Um, and also keep in mind that a lot of these recommendations go beyond what a lot of courts are affirmatively going to require. Now, I do note, and I think I mentioned this at the beginning, that doesn't mean that that can't theoretically come back to be a problem for you in the future if things go wrong. Um, but so long as you are, you know, responsibly and appropriately managing those funds, and you're being transparent about how you're carrying that out, um, then in most circumstances, you're not going to have much to worry about.
But I will say, if your child has also moved counties to go live in a group home or in a waiver home, you do absolutely have to inform the court of that too, that they
Yes.
have moved. Okay.
Yeah, that is a good point. And kind of, I think I mentioned that in that portion. Technically, per statute, you are supposed to get the court's approval before the individual relocates to another county. That's not nearly as big of a deal as someone moving out of state. So long as you inform the court and make sure that the judge is aware that they're no longer living in the county, that would be the first recommendation. And then part of why that's important is because, it's not uncommon for a guardianship to be established in one county where the individual maybe grew up. So for example, um, one client I had years ago, they grew up in Kosciuszko County, but then they had been living in Evansville down in Vanderburgh County for 20 years. And until I had to get involved for problems relating to the guardianship, the judge in Kosciuszko County had no idea that this person had been living hours away for the last couple of decades. Um, so that was among many issues in that case. The judge was not happy there. But for the most part, so long as you're keeping the court apprised of where they're living, and if it's going to be a long-term arrangement where they're no longer living in the original county, it might be appropriate to seek transfer to that different county. Um, because if they are going to be living elsewhere long-term, that is the court that should have oversight over the guardianship rather than just the fact that a guardianship was established in one county doesn't necessarily mean that's where it should always stay.
So our next question, I'm feeling very overwhelmed with what I need to provide to the courts in the future for my child. She's 16 years old. Does anyone provide what kind of questions to answer for the courts?
So I think that kind of relates to the question we covered before about that is a question you can simply ask the court staff. Um, you could theoretically ask that of the judge during the guardianship hearing, assuming that you move forward with seeking establishment of it. Um, that may not be received well by all judges. Um, so I guess I should back up. First, um, I would consider getting an experienced attorney who's knowledgeable in this area um, to assist with first assessing whether guardianship is genuinely necessary, and if it is, um, helping establish it. If that's not an option and you do have to go pro se or unrepresented, then typically asking the court staff what information needs to be reported is going to be the best.
Okay. I have a son that we try to do supported decision making with. Do we need to have it more formalized? I'm nervous if he should get into legal trouble, either with police, tenant problems, or online scams.
So supported decision making is great because it works as a legal instrument, but it also is a general concept. And so it can be used very informally, whether outside or as part of guardianship. Um, as far as a formalized supported decision-making agreement goes, that might be an appropriate option. I know I do a good amount of options counseling with individuals and families, kind of talking through um, what types of supports might be appropriate other than guardianship so that we're avoiding even setting it up in the first place. And to clarify, I don't set up guardianships, but so that I can help them avoid going down that road. Um, and uh, what, sorry, I lost my train of thought there for a moment. Um, my, I was not expecting to go this long, and so my stomach is beginning to distract me because I haven't eaten in several hours. Um, can you remind me of what that question was? I'm sorry.
Oh. They were asking, do they need a formalized supported decision-making agreement? And what they're concerned about in particular are things like, what if he gets into like legal trouble with the police, or tenant landlord issues, or online scams?
So there, again, that's another one of those kind of it depends situations. Having a formalized SDMA might be helpful in those sorts of circumstances, just because, and I guess it it might be helpful to know what an SDMA is, a supported decision-making agreement, and without kind of reviewing the actual physical document itself. And there's not a required document for an SDMA, but we at Indiana Disability Rights, we do have a template supported decision-making agreement that you can find on our website along with various other resources. Um, but what I describe it as is a way to kind of take all of the informal and formal supports that the principal to the agreement, or the one who would set up to benefit, that they're receiving or that they want, and to be able to distill that down into a single document so that they can specify exactly what areas of life they want assistance with, who they want that delivered by, and how they want that provided. Um, and so it's not always extremely beneficial from a practical aspect for a lot of folks who I talk with to set up an SDMA, but the process itself can be very beneficial just to work through, if nothing else. Um, And something I do want to know that's very unique about SDMAs versus something like a healthcare representative appointment or a power of attorney is that there's no decision-making authority actually conveyed. But it is something that, you could take the form and let's say it spells out that I want um, mom to be able to be co-owner of my checking account with me, and to be able to, um, you know, receive bank statements and help me manage funds and things of that nature. You'd be able to take that to the bank, and that might simplify the process of being able to set that up. Or you can specify that you want someone to be able to assist you with uh, managing your uh, medical or mental health care in a limited capacity. And um, a lot of times there's crossover with other potential decision-making supports as well. Um, so yeah, that's the short answer is you don't have to have a formalized written document to utilize and benefit from supported decision making, but it is something that can be appropriate and helpful for some folks.
So somebody's asking, if my standby guardians are older like me and pass away, my son may need a paid professional guardian of the person. I don't feel comfortable with hired guardians. Do you have any thoughts? Yes.
Unfortunately, no.
Oh, see, I do.
Okay. Well, other than kind of thinking about maybe uh, options other than guardianship that you can get in place, I was interpreting that as like suggestions for paid professional guardians.
So I'm gonna chime in here. I think there are a few things. First of all, again, it's about building that circle of support or that network of support. And somebody else asked about that, so I'm gonna go off on a little tangent about that. That is developing relationships with people, and that doesn't have to mean super deep relationships either. But it's basically creating point people in our loved ones' lives. So that, for example, if cousin Nikki is a nurse, hey Nikki, if Andy has any questions about his healthcare, can he call you and talk with you about that? Or, even the neighbor, hey Don, we're out here every day. You guys know Andy really well. If Andy's ever home alone and something has happened, maybe the smoke detector's going off or something's buzzing, can he come to you and ask for help? And so sometimes it's little things like that, um, where you're broadening the network of people that they can turn to, and you're creating some of those trusted relationships, even on small things. Because I think sometimes we think that everything has to be all or nothing, and it doesn't. We can designate different people in our lives that we turn to for different needs, and so building those relationships, whether it's people in at church or at your synagogue or your mosque, whether it's getting to know the people at the library, which I know sounds a little bit strange. Why would they be part of it? Well, if you need to look something up at the library and you've already developed relationships with the librarians, and you go to them and you say, hey, I need help finding out something about Social Security, they can help you find the information you need. Or if you need to fax a document somewhere, because some of the things we deal with still use fax machines because it's 1990, they can help fax a document, or whatever the case may be. So that's what I mean by those networks of support. And so if we're concerned about, whether those standby guardians will still be available, first of all, like Justin said, keep growing those networks of support and ideally help somebody work off of guardianship if they can. If not, start by identifying, and maybe we can get some people who might be comfortable stepping in some capacities, and maybe you have one person who's guardian of the estate and somebody else who's guardian of the person, because especially even with siblings, becoming guardian over all of that can be really overwhelming and they're afraid of it. But if we break it up and make it manageable, that's something that they may be more willing to do. There are also volunteer guardianship programs. Now, these are individuals who are professionals, and but what makes them a volunteer guardian is that they don't charge the person a fee to be their guardian. And that's kind of the biggest distinction, at least in my opinion, between a professional guardian and the volunteer guardian, is payment.
I do
Here,
note a small correction.
okay.
Um, while that was true of all the FASIA programs that I think
Mhm.
you're referring to,
Yeah.
those are volunteer advocates for seniors and incapacitated adult programs.
Hmm.
Many of those have begun charging fees for clients, but they typically will do sliding skis, sliding scale fees,
Okay.
so that individuals who don't
Okay.
have the ability to pay fees may not pay anything or pay
Mhm.
very limited fees, whereas
Okay.
if they are required to step in for someone who has significant resources, they might charge similar rates or sometimes even more than paid professional guardians. But I will note that VASI programs do tend to take uh, things like training requirements and utilizing supported decision-making principles and things of that nature much more seriously than I think paid professional guardians often do. And that's not to say people who are, private paid professional guardians are necessarily bad. It's just the current incentives under state law, um, sadly don't favor paid professional guardians really taking the time and effort to practice some of those efforts.
So it's certainly something to look into and investigate for your particular area. The VASIA or volunteer guardianship programs that Justin was just referring to, they are available in close to 60 counties at this point. You can Google VASIA Indiana, and you'd be able to find out where those are. Okay. But this actually, what you just said, runs into a comment that a self-advocate has shared. I did request the court order me to follow the national standards of guardianship as it pertains to decision making. That's worked very well for me. Have you heard of this being used in Indiana?
See. So I believe that was an Ashley Porter, and
Yeah.
so that's is Ashley the individual under guardianship or the guardian?
She's a self-advocate.
Okay. Um, so that's something that an individual court absolutely could order a guardian to follow. And I think that's
Mhm.
a great bit of self-advocacy to push for that and to get the court to order that a guardian would have to follow those standards. Um, whether that's going to be required for guardians in Indiana to have to be nationally certified, I don't know the likelihood of that. Um, personally,
I
oh, go ahead.
I will say because this is a question somebody asked. Um, I can't guarantee one way or the other what's going to happen. I will say that there are discussions being taking place at several levels about whether or not to require certain training or certain certifications or things like that. So those things are being discussed. I don't think there is any consensus or that we're close to any sort of consensus on that, but discussions are being had is how I'll answer that.
Mhm. A lot of it comes down to getting funding for these
Mhm,
programs that I think
mhm.
everyone recognizes are needed. Just a matter of
Mhm.
how they get paid for and getting our lawmakers to prioritize allocating funds for those things.
Okay. Somebody has a simple question. Does my child need to file taxes if they're under full guardianship?
That would be a matter of whether they work. If I'm not an expert on SSI versus SSDI and when taxes like what's countable as income and what's not. I believe one technically is, one isn't. Um, so that's something guardianship itself would not impact that. I think is the best and
Right.
simplest answer I can provide there. So yeah, if they are working sufficiently or otherwise have income coming in that would otherwise require them to file taxes annually, then even under guardianship, those would still be required to be filed. Yes.
So we just have a few more questions. What do you do when a guardianship is not doing what an adult protected person wants for their life and is violating their rights continually? You call Justin.
Yeah. You can call IDR. Indiana Legal Services has some attorneys who work in this area as well. They do have a particular project called the Legal Assistance for Victimized Adults, or LAVA project, that is focused on assisting um, individuals who are considered endangered adults, whether that be by reason of age or disability, who have been victims of crimes. Um, and I highlight the Lava Project in particular because while they aren't a large program and don't have, a ton of attorneys working for them, I believe they have a team of 4 or 5 attorneys, and they're spread out throughout the state. So I do always like to plug them because they are a great resource. Um, Whereas IDR is a very small statewide agency, and we're located out of Indianapolis. Um, as far as how to address that, you know what? Why don't you just go ahead and call IDR, even if we can't assist directly with the case, we can provide some um, you know, basic information about what your options might be and potential referrals. Because
Their
I'm,
number is their number is 1-800-622-4845.
yeah. And then if you happen to be local to Central Indiana, you can also reach us at 317-722-5555. And the only reason I'm not providing a direct answer to that is just because, like we've noted, it depends so much on the county. In some counties, I would say you could write a letter to the judge, letting them know what's going on, and the judge would take that very seriously and set a hearing and demand that uh, you and the guardian appear and talk through things. Unfortunately, in other counties, the judge might you might file a letter, and I'm saying this because I've seen it multiple times in some counties where the court says the court has received this correspondence from the protected person or someone else. Unfortunately, it was not filed according to the appropriate standards for legal filings and with appropriate notice to various parties. And so the court's disregarding it. Um, so yeah, that's unfortunate, but the reality of the situation. So I'd prefer you reach out about the specific circumstances of the situation. And like I said, we may not be able to assist directly, but if nothing else, we should be able to provide some guidance and referral information about what your options are.
What would be the first step in finding out how to set up a TrueLink card?
To be honest, I would say Google. Um, I don't know, Carly, you probably
Yeah, that's exactly what I would do. So, and please understand, it's not that we're trying to be flippant. It's that,
yeah.
yeah, oftentimes that's the first place we're starting with research. So, because a lot of times that will start giving you a guide on all of that.
And I I believe TrueLink is kind of a standalone entity.
Mhm.
Um, it might be at the point now where some banks have it integrated into accounts. I know with like the TrueLink accounts, that's something that a lot of big banks started offering as part of their uh, other accounts.
Mhm.
Yeah, I Googling TrueLink account now, and okay, and apparently there are a lot of options. So unfortunately, um,
We're not going to be able to give you a quick answer to that uh, other than go ahead and Google, talk with your bank as well. It's a
yeah,
good place to start as well, because there may already be some options that they have available to you that would be free to use or could be included in the account that you already have set up. So there may be several options that way as well.
and that's something if uh, you have a case manager, if you're a guardian of someone who has a case manager, if they're involved in waiver services or something like that, they could be a good resource as well if that's something that they probably encountered and needed to provide guidance on in the past.
I know that's something that our trust has also done for individuals as well. So, my daughter is now 15 years old. How much time should I expect a guardianship to take the court to process? At what age should I begin the process? Well, I'm gonna step in here for just a second because I'm
Yeah.
gonna say at 15, go ahead and start, teaching some of those skills already. And really look into some of the alternatives that could be available to you. Now don't get me wrong, there are times where guardianship is necessary and appropriate, so I'm not discounting that. But a lot of times we can always start with a less restrictive alternative first. And if it's not enough, we can always go for something more restrictive later, but it's really difficult to go the other way.
Mhm. And you're really at a great point to try and explore those options and see if those skills can be built um, prior to looking at guardianship as a formal option. Um, as far as answering that question directly, um, the process from the time of filing a petition, typically that's going to be anywhere from a month to a few months before a hearing would be held and the court would make a decision on that. Um, I believe under statute for an adult guardianship, it's either I want to say it's 3 months prior to the 18th birthday, a petition can potentially be filed. Um, but that could be, don't quote me on that. Um, so there is the potential option to file a petition before the 18th birthday. So that's already in place, but yeah, like Carly said, right now is the time to um, really explore and see if there are other options other than guardianship that.
And also, even though it's only a few years away, there's a big difference between a 15-year-old and an 18-year-old, you
Yes.
know. I mean, and that's just universally true.
And
Um,
even at 18,
mhm.
disability or not, no one comes out knowing how to take care of everything on their own.
We all made bad decisions when we were 18. It's just a matter of how bad were they? But you know what? We also learn from those bad decisions that we made at 18, and so there's value in that too. So, and then our last one. As a guardian for a person with a disability, I stress talking to them about their wants and needs. We want them to have a great life and be happy. Letting them make those decisions is incredibly important, and I could not agree with you more. So,
Absolutely.
Justin, thank you so much for joining us tonight. For those of you who joined us, thank you. I hope that you found this helpful. If you have more questions, or if you think of something like 3 weeks from now, give us a call here at the ARC. Talk with one of our family advocates. We can talk about your specific situation and kind of dig into those details more. But know that you're not alone in any of this. And again, we've got resources on the ARC of Indiana's YouTube channel, on the ARC Academy, so that you can go back and learn some more and explore that a little bit more. We also have we also have recorded this so that this will be posted to our YouTube channel as well, so that you can go back and watch other parts when you need to. But thank you all so much for coming tonight. And Justin, thank you for taking the time and for taking so much time, because I know this was a lot longer than I had warned you about. And thank you for staying and answering everybody's questions.
Thank you for having me, and thank you to looks like we've still got 25 people who've hung on for the full 2 hours. Um, so yeah, thank you,
All
everyone who's stayed on and participated.
right. Thank you, everyone, and have a good evening. Bye-bye.